Welcome to our webinar, The Anatomy of an Employment Law Case, What You Need to Know to Avoid a Lawsuit. This is the first in a series of webinars that the Labor and Employment and Human Resources Practice Group at the Wagner Law Group will be offering in 2013. This presentation will last about 30 minutes, and the slides from this webinar and 5 webinars from last year are available on the Wagner Law Group website. Let me introduce David Gabor of Counsel with the Wagner Law Group. Welcome, David.
Thank you, Barbara, and hello, everybody. Today we're going to talk about ways to control risk, and we're going to focus on claims that are brought in employment law cases, either by current or former employees or by administrative agencies such as the Internal Revenue Service or the Department of Labor. We're going to explore the causes of litigation, and we're also going to talk about the roles that records and documentation play in the employment law arena. The types of cases we're going to explore today are cases based on harassment, whether that's sexual harassment, racial harassment. We're going to talk about discrimination, maybe a wrongful termination case. We're going to talk about hire and promotion cases. We'll talk about compliance matters, such as wage and hour cases, and we're also going to talk about accommodations and the FMLA and Medical Leave Act. We're going to talk, after a brief background in the area, 10 reasons why employment cases are brought. And the concept is, if we understand why the cases are brought, we probably can understand ways to avoid having cases filed. My background, briefly, is that I have represented employees and employers in employment law cases. I've defended employers in cases brought by administrative agencies, and I have for years been a mediator and an arbitrator. And during my time as mediator and arbitrator, I learned a lot about why these cases are brought, and I also understand the perspective of the employee and the employer in the cases. First and foremost, it's important to understand that in discrimination cases, typically the employee has the burden to prove, more likely than not, that there has been wrongful acts taken by the employer. And that's established either through direct or circumstantial evidence or both. Direct evidence consists of testimony, which is questions and answers, and exhibits that directly support the matter asserted. Circumstantial evidence is layered on inference upon inference. Imagine, if you will, you're in a conference room. When you walked into the building, it was partly cloudy or mostly cloudy outside, and you're there for about an hour or two. You have no window to the outside world. Then you see a person walk in with an umbrella, and that umbrella is wet. About 30 or 40 minutes later, another person comes in with a raincoat that is wet. More likely than not, is it raining outside? This is the type of charge judges give jurors when they talk about circumstantial evidence. And they also tell the jury circumstantial evidence is of no less probative value than direct evidence. And we're going to relate these charges to understanding not only why these cases are brought, but what the employee and the employee's attorney look for when trying to prove these cases. Now, on matters of compliance, it's a whole different game. In the compliance arena, the employer, not the employee, typically has to prove compliance. So, for example, in a wage and hour case, the Department of Labor or the IRS would expect that the employer has clear records of the number of hours the employee worked each week, what that employee's terms of employment are, and also whether that employee has been paid fully and properly for every hour worked, including appropriate pay for overtime if that employee is eligible for overtime. That is the employer's burden. Why is this relevant? Well, the employee's lawyer is looking for smoking guns. They're looking for direct evidence, that memo or that document that says, let's get rid of the old people and get some young blood in here. We don't want working moms in this company. If they don't get the smoking guns, they may look for statistics, the percentage of people at different levels in the company. Let's say, for example, middle level of management is 50-50 male and female, but senior management is only 1 or 2% female. That's the kind of statistics they're looking for. Documentation. Is there a different way in which employees of different race or different age, et cetera, are being managed? And then in a discrimination case, the Employees Counsel may also look at compliance because they may think that they can use a failure to comply, for example, in maintaining proper hours worked, that failure to comply could be leveraged to force a better settlement in a discrimination case, even though one has got nothing to do with the other. So the first thing we're going to talk about are the policies in the company. Typical policies that play a role in defining the workplace, the employee's responsibilities, and also govern compliance with the employment laws are the wage and hour and personal time off or PTO time. Time and attendance policies. What do we do if an employee shows up late? Employee classification, whether it's a part-time or full-time, eligibility for benefits, whether it's an independent contractor or an employee. Acceptable behavior. We do not tolerate discrimination of any time. We do not tolerate any harassment. That is something that needs to be clearly spelled out in the policy. Hiring and promotion. When we promote people, do we open it up to all employees who are interested to apply, or is it a tap on the shoulder? How do we manage the employees? Do we have verbal, then written, then suspension? In terms of a progressive discipline policy, do we do annual performance evaluations? Are we making sure these things are actually being done in the company? That should be spelled out in the policy. Benefits. Do we provide benefits, whether it's health insurance, a retirement plan? Lay that out in the policy manual. And the complaint mechanisms. If you perceive wrongdoing, whether it's discrimination, whether it's an OSHA matter, a health or a safety matter, where do you go? Who do you go to bring this point to the attention of the company? And clearly, do we have leave policies? Family Medical Leave Act, the ADA, accommodations, all these things need to be spelled out in the policy. The exposure arises when the policies are either vague or unclear, when they don't incorporate legal obligations and they're stale. If we don't clearly lay out, for example, that there is a complaint mechanism, that we do not tolerate discrimination, then we lose the ability to use something that's referred to as an affirmative defense if a case is brought. The affirmative defense is the company has a viable, clearly defined anti-harassment policy. They have a complaint mechanism if an employee perceives that there is some form of wrongdoing. And if the company does not take advantage of that complaint mechanism and that policy, then that can be used as an affirmative defense by the employer in court. When the policies are not clear, employees get to be frustrated, and there's a dissatisfaction that they have with the employer, and that impacts their work and what they'd say outside of work about the company, which we're going to talk about in a few minutes. And ultimately, there's an increased risk in the number of claims that are being brought. Some companies have a wonderful employee manual, but they don't properly disseminate it to the employees. And that gets to be a real problem. So you can have the greatest manual in the world, but nobody knows about it. All employees must follow the policies. That's got to be clear. There are many instances where some people are following policy 1, other people are following policy 2. Some people don't even know about policy 1 or 2. Believe it or not, I've seen that time and time again. There needs to be a method to ensure there's consistent compliance with the policy. 2 supervisors, A and B. A will write up every employee who's late, which is a time and attendance concern. B is tolerant of employees being late so long as it's not a half an hour. So employees who work for B are perceived to be treated in a favorable manner as compared to employees who work for A, and that creates major problems. At the same time, Supervisor C has 5 or 6 employees working for Supervisor C. 4 or 5 of them are male, 1 or 2 are female. One of the females shows up 10 minutes late to work and is written up. The guys show up 10 minutes late to work and they're not. She's going to cry foul. Also, make sure to verify receipt of the policy and all updates by each and every employee, including senior management. What's a risk? Again, that frustration, discord, and animosity. And what happens is a person working in a company that's got a clearly defined employee manual that's disseminated and there's consistent application of that policy manual comes home from work and the significant other says, "How was your day?" "Honey, I had a great day. I love working for X Corp." The person who works for a company that either has a sloppy manual or does not properly adhere to the terms of the manual, that person comes home and says, "Honey, I had an awful day. I feel like I'm just being treated unfairly. I've got no direction. It is so frustrating." Well, when people start talking like that at home, what happens? "Oh, you know, you're being treated unfairly. You should go see an attorney. Go talk to Greg. He's a great lawyer. He'll help you out on a case. Maybe you've got a case." Now they're starting to go talk to lawyers. Another risk is disparate treatment. Like I said before, it might be a male versus female situation, and even though when the policy is created, the intent was to eliminate that possibility, because not everybody is following the policy's terms, you can have that risk. Favoritism, that's a matter of perception, and that's one of the things that oftentimes drives an employee to a lawyer's office. When they do go to the lawyer's office, the first thing the lawyer is going to do is look for flaws in the policy manual and whether or not it's being implemented according to the terms of the manual. That's one of the first things lawyers look for. And if you're not properly applying the manual, or you can't establish that it's been disseminated to everyone in the company, the employer might lose the affirmative defense that we talked about earlier. Training. So many people don't train as often as they should. The areas that need to be focused on in training are harassment, discrimination, safety, and employee management. And some companies say, "We don't have a budget for it. We'll train next year. We don't have the time to get to it." The other companies say, "We just don't have the resources." And what happens is, by failing to have training programs for the employees at all levels about what is and is not tolerated in, for example, sexual harassment or other forms of discrimination, how we should handle dangerous equipment or chemicals in the company, how we manage employees, for example, progressive discipline, a verbal warning, a written warning, suspension, possible termination, and to ensure that everyone is working with the same policies. If we do not do that training, once again, we're increasing the risk not only of the number of claims that can be brought, but how much each claim will cost to defend and possibly to resolve through settlement. Communication. Many of the situations that have been brought to my attention as a mediator arose because of poor communication in the company. And what happens oftentimes is an employee's got a little problem. They want to talk to the manager or they want to talk to human resources, but the manager is not prepared for that conversation. The manager doesn't know what to do if the employee says, I'm not feeling very well, I've got a problem, I think I need some time off, or I think I'm being treated inappropriately, Bob is leering at me, he's giving me a hard time. They don't know how to respond. And that kind of mistake can be very costly. So other managers might be defensive or dismissive. Believe it or not, there are cases where someone makes a complaint of discrimination and the answer from the manager is, boys will be boys. Jim, that's just the way he is. Other managers may talk too much. For example, and this is a real case, a person makes a complaint of discrimination. The manager says, "Oh my God, that is the worst thing in the world. Wow, I can't believe they did that to you. That's awful. That's terrible." You know, the people here are just awful. And that becomes evidence in the court case. In another case, the manager's response when an employee said, "I need to take some time off and leave," you know, we need people who can show up to work here. We can't tolerate having people take time off. That manager, by the way, was the head of HR of a large company. Promises that are not kept. An employee makes a complaint. The manager says, "I'm going to talk to HR right now. They'll get back to you within 60 minutes. Stay by the phone. They'll get back to you." And HR doesn't call for 2 or 3 hours or maybe the next morning because HR was tied up for some legitimate reason. Now you've got a very upset employee who's been waiting by the phone and feels that they were not respected at all by the manager and by the company. Or managers are perceived to be too busy. And employees sometimes feel like they're out on an island and no one really gives a dang about them in the company. And what happens is simple, resolvable issues. A simple misunderstanding between two employees can become an expensive, drawn-out employment discrimination case in federal court. And once again, when the employee feels neglected and they go home and they tell their friends and family, you know, "I had a problem at work and I went to Dave in HR, he blew me off," or "my manager blew me off," that's when, once again, they get referred or introduced to an attorney, or if, you know, someone who's called, and no disrespect to people in Philadelphia, a Philadelphia lawyer. And now they're looking at dollar signs instead of a simple resolution of a case. There are times where the response by the company may be poor and even illegal. For example, an employee who's got a proper right to Family and Medical Leave Act could be told, "No, you can't take leave during the next month and a half. We're too busy." And that may be a wrong answer to give, and that answer might create litigation. So we need to make sure that we avoid the mishandling of these complaints, and communication, again, is critical. Accountability. This is a word we all hear all too often in many different areas of our lives. And in organizations, it's so important that all levels of the company are accountable. They've got to be held foot to the fire to get things done on time. That way, these great employee manuals that have been properly disseminated to all the people in the company are followed the same way by every manager at every level in the organization. And if we don't do that, then we've wasted the effort taken to create this great manual, and this has repercussions both of a legal and a business nature. When there's no accountability, we're more likely to have potential claims of discrimination because we're having issues arise that are avoidable. For example, disparate treatment. Once again, if two different managers are applying the same manual differently because one doesn't bother to write people up if they are late or they're not getting the work done, and another manager is writing people up, or maybe they're not doing a proper job with performance evaluations, or they're overlooking things such as time and attendance, you've got those discrimination claims, you've got disparate treatment claims, you now have disgruntled employees. You've got confusion because there is unclear direction in the company. Now employee engagement suffers, morale suffers, performance suffers, and that's simply because we've got a situation where not all people are being held accountable in the same manner. Retaliation is a topic that I've touched on in several prior webinars, and I will continue to do so in the future because time and time again, judges are telling me that retaliation is the easiest thing to prove in the employment discrimination field. All the employee has to do is show that the employee engaged in a protected activity. That is bringing a complaint of some form of discrimination to the attention of the company, to an administrative agency, or in a court. The employee does not even need to be correct. They just need to reasonably believe there was some form of discrimination. That the complaint was followed closely by an adverse employment action. That could be a firing, a demotion, a reprimand, a warning, a change in title, a change in hours or shifts or location. That is all it needs to do is be something that would dissuade a person from complaining. Here are some steps to take because of the risk of retaliation. Make sure that your policy manual and any written updates clearly address retaliation. It is not tolerated in your company. It's important to talk with the complaining employee. Make sure that HR sits down with an employee who's got a complaint. Listen to the complaint. Make the employee feel that they are a person who's valued. Then confirm that the company does not tolerate discrimination in some form of a writing to the employee. You've got a record now. You met with the person. You took your notes. You told the person in writing, we do not tolerate any form of retaliation. And then you follow up with the employee. A few weeks later, how are you doing? How are you making out? You know, we're working on an investigation. Just want to make sure everything's all right. Then also make sure that the complaining employee does not suffer a tangible employment action without first doing proper due diligence. A tangible employment action, again, would be a warning, a change in shift, a change in hours, some form of any kind of a written warning, verbal warning, counseling, anything that would be a tangible employment action. Make sure that does not take place without due diligence. And also follow up within the department just to make sure the employee is being treated the same way the employee was being treated prior to the complaint. Of course, if there was some form of discrimination like harassment, we don't want that to be continuing. Another thing, and this is a hot area, is the Family Medical Leave Act and accommodations. This is an area that has faced a tremendous amount of attention on the part of the EEOC, and Equal Employment Opportunity Commission. They've made it a priority, and it's important that we rethink how we handle employees with medical challenges, either their own or an immediate family member. And it's not an area that's easy for employers. I understand that, but it's something that you've got to think about. There's something called an interactive process. And that interactive process is something that we're going to address because that's the change in the philosophy. When a manager becomes aware that an employee has got some form of medical problem, the manager's knee-jerk reaction of saying, no, please, you can't take any time off because we need you, or of course you could take all the time off in the world, isn't the solution. The manager needs to know what the policies of the company are and how your company wants that manager to respond. The test is no longer whether or not the employee is disabled. Now what the law wants employers to do is to see whether we can get that employee back to work. So the best thing to do is make sure there's a good partnership between the HR department and the online managers so that the managers know how to deal with these complaints, and when in your organization the manager must report to HR, preferably before the manager says something inappropriate to an employee. Then we get into the interactive process. This is what the courts, EEOC, and the law wants. They want the employee to tell the employer what they believe would be a reasonable accommodation. Then the employer determines whether or not that's reasonable. If it is, let's go with it. If not, come back with something that would be reasonable and go back and forth until you can find a reasonable accommodation if possible. Another thing that's a concern is written communication. There was a case recently that cost a company several $1 million because they wrote letters to employees who were out on leave saying, when you are 100% healed, come on back to work. Unfortunately, that eliminated the ability of employees to come back with a reasonable accommodation. That cost several $1 million. And finally, please ensure consistency between different requests for leave, because we don't have one law that applies. There may be 4 or 5 or 6 different laws that apply. So for example, if we're more lenient to men who take leave than women, or we're more lenient on one race as opposed to another, or people who are younger as opposed to people who are older. They can say, my rights under FMLA, the ADA, Title VII, ADEA, state laws, city laws may have been violated. So it's not one or two laws. There are several laws that oftentimes apply. And documentation. This is an area that's frustrated me to no end in many, many cases. Documents basically fall into three categories. The documents that exist, they are what they are. These are the documents on the case. The documents that we wish we had, which we're going to talk about in a few minutes, and the documents that, oh boy, I really wish this company didn't generate this document. What were they thinking? And again, the documents do play a critical role in resolving liability in these cases. Oftentimes, once you look at the documents, the truth goes out the window and the documents govern the case. And sometimes cases are resolved not because this is what really happened, but because we cannot prove what really happened. And in the compliance and the wage and hour cases, the documents are critical. Basically, they decide who wins and who loses. It's important to be aware that a litigation hold is placed on a case at the time that the company is first aware of the controversy. And that means that all those records are supposed to be maintained. If they are, good. If they're not, there could even be a negative inference drawn that the reason why they were not maintained is because they would hurt the company's position. And by the way, emails between different people in a company may be discoverable. So one of the things to think about is making sure that in your company you have got a clear policy and you make it crystal clear to senior level people and managers that any emails they send between each other are discoverable in cases. I have seen on many occasions intra-office emails that senior managers thought were private that said why acts were taken against employees. And the reason became an unlawful reason and the cases had to be settled. And the absence of records is something that plays into the employee's lawyer's hands. And remember that the employee is going to be looking for clear documentation of why they were treated badly, and in compliance cases, the IRS or the DOL or whichever agency you're in front of is expecting the company to be able to prove clearly it met all of its obligations. Here's what you do. Conduct periodic audits to determine compliance. Let's take a look and make sure we are tracking all of the wage and hour records we need to track. We're making sure that there is no local statute that we're not aware of. And this way we can confirm compliance so that when an audit does happen, we're ready. You've got to be ready before the audit, not after the audit. In discrimination cases, do a periodic audit. Are there statistics in this company? Maybe it's age, maybe it's gender, a glass ceiling case that could hurt us in court. Maybe we have one manager who is doing a better job or a more proactive job of managing than another and has created an appearance of disparate treatment. Also, when we audit, let's make sure that we don't have emails going back and forth between people in the company that would be harmful to our position. And finally, those records, at the very least, hold them for 6.5 years after the last day employees work for the company. And let's talk now about a paper trail, because as I said before several times, this is what the employee's lawyer is looking for. So imagine this, and this has happened. We're at a conference in front of the judge on the case, and the plaintiff's lawyer gets up and says, oh, poor Paul, he was fired for unlawful reasons. He was treated horribly in a different manner. He is suffering greatly. He's lost money. He's lost sleep. He's been sick. He's seen doctors, all these terrible things. And the judge leans over the bench at defense counsel and says, Mr. Gabor, surely X Corp has documented the quality of Paul's performance. At that point, I would love to be able to say, yes, I've got a paper trail verbal warning, a written warning. I've got, a 2-week suspension. I've got performance evaluations that reflect this information. But sometimes I don't have any of that because the manager did not do his or her job properly, at which point I do my best Ralph Cramton of the Honeymooners impression, ahamina, hamina, hamina. And you really don't want me doing that when I'm in front of the judge on your case. So employee management is critical from a business standpoint and for a legal standpoint. We need to show that we follow progressive discipline. We need to show if an employee is late, we call the employee out on it. And then if we do have to terminate an employee, we've got the paper trail. And oh, by the way, if you use performance evaluations and you've got choices between satisfactory, unsatisfactory, or exceeds satisfactory, and an employee is not satisfactory, don't write exceeds, because that becomes a major problem when we're in court. Counsel is going to look for no discipline of the employee. And if the company says, oh yeah, we did discipline the employee, we spoke to her on several occasions, then they're going to look for the lack of a record of discipline, no documentation, nothing in the employee's file to show the employee was disciplined, that the performance evaluation is fine. Ms. Gabor, why did the company let this person go? Because of time and attendance problems. I don't want to see a performance evaluation that says that the time and attendance has always been good for that individual, especially if that's going to be a few weeks prior to when the person was let go. The other thing that the attorney will look for is, okay, maybe Bob did do the things that you claim Bob did, but so did Fred, Steve, Joyce, and Ellen. They all did the same thing, but they were not, disciplined. Finally, let's talk about supervisors. One of the things that happened many, many times in companies, again in cases I was involved with, is people were promoted into supervisory positions who had no desire to be a supervisor. They liked doing the work they do, but they did not want to embrace the responsibilities of employee management. And these are the people who all too often may be good at their work, but they don't lead the employees, they don't manage the employees, they don't discipline when necessary, they don't get involved in the employee management process. When you promote someone to a supervisory position, look for the traits that are needed to be a supervisor, not just to reward the person for good performance at a lower level. The danger when a supervisor is either unable or unwilling to handle the responsibilities is an increased risk of claims being brought and increased exposure in the claims that are filed, and also in confused and frustrated employees. Now, I'm going to go over some final tips, and these are only some of the many things I hope you take away from today's program. Make sure that the policies are current. Make sure that you're aware of rules in each and every jurisdiction where employees work. For example, New York has got a Wage Theft Prevention Act that requires that every employee signs a piece of paper acknowledging they've been advised clearly of their pay, whether they're exempt or not, except from overtime and things of that nature. Make sure that your policies are disseminated and that the employees have acknowledged receipt of the policy. Hold the employees accountable. Budget for training. There are different ways to train that are not as expensive as they may seem, but please take the time to train. Be careful for retaliation. Make sure that all your managers are prepared for issues such as family medical leave issues and requests for accommodations. Conduct audits. Make sure you've got the records that you need to have to defend discrimination and compliance cases. Make sure you've got the paper trail for the employees, especially in things such as termination cases. And be alert for those damaging emails. And make sure they're just not happening in your organization. It is so dangerous. And thank you for taking the time to participate in the webinar today. If you've got any questions regarding the topics that we discussed, I know we went through quite a large amount of information. Feel free to reach out to me about this. And also, if there are other topics you'd like to talk about this year in webinars, please feel free to give me a call or send an email to me. Thank you again.
Thank you, David, and thank you for everybody who attended. A recording will be available on the Wagner Law Group website shortly if you'd like to access that. Thank you.